Then my attorney just said they settled for $20,000 and I would get $8,000. I was like, what? The amount itself was not the biggest thing. I just needed to know how and if this was a fair amount or not before I could agree. Hi, my name is Sergio Ardila, and for the last 8 years, I have been the best attorney here in my department in our Morgan & Morgan Atlanta offices. Today, I'm going to attempt to finally fully explain how to value your car accident case and how to figure out how much it's worth so that either you understand why your attorney got the settlement he or she was able to obtain, or how maybe you can try to negotiate it on your own. At a minimum, you will understand the components that give your case value. Now, whether you agree with the value you can get on your case is a whole different matter altogether. But I will also try to discuss things that can increase the value of your case. Lastly, please remember that this video does not create an attorney-client relationship. I am likely not your attorney, and if I am already your attorney, you can contact me with any questions personally or through my team. And this information is all information that you can research on your own, but I'm compiling it here in a concise video for you. We are in Georgia, so some nuances might be specific to the state and might differ from your state. Okay, let's get into it. A car accident case has three big categories where the value comes from. Oftentimes, we can describe the value as damages because, broadly speaking, for you to get compensation, you need to have suffered some form of damage due to the negligence of the other driver. If the accident was your fault, most attorneys do not typically get involved, although there are some ways to help you here, as well as increase the value, but we can get into that later. Damages fall into three categories: economic, non-economic, and punitive. And to write them in the same form as my other videos, we will illustrate these three as buckets, just like in our workers' comp videos. Economic damages, also known as special damages, are the economic losses you sustained because of the accident. The most common types of economic damages are medical expenses and lost wages, which we will draw into two subcategories. Under the collateral source rule, you are entitled to claim the full amount that your medical provider bills, regardless of whether they have been paid by your health insurance or some other source. This is important to remember because many people believe that they can only claim the bills that they actually paid out of their own pocket, such as the portion of the copay and the deductible. There are some nuances here if this does go into litigation, so keep that in mind. The medical expenses must be reasonable and customary charges. You can't get a nose job if you hurt your knee or your shoulder. That's an example of it. Another issue could be if you get a brand new groundbreaking treatment that a jury might not find reasonable and customary, especially if it seems disproportionately expensive. Likewise, you still get to claim the lost wages if you miss time from work but still receive payment for your missed time. For example, you may receive payment from using accrued leave time, a disability policy, or workers' compensation coverage if the accident occurred while you were working. In this scenario, the collateral source rule allows you to claim the missed time from work as lost wages. There are also nuances here, as many policies don't cover dollar for dollar the things that are already covered, like the initial workers' comp amount you get. But you can still claim the difference between what workers' comp gives you and additional losses. You may have additional out-of-pocket expenses that you are entitled to claim. For example, you may have to make frequent trips for medical treatments, or you may have to pay somebody to perform tasks that you normally performed, such as household chores, going to the grocery store, or doing yard work. It's important to keep an accurate record of any out-of-pocket expenses, including any documentation such as receipts that show what you paid. A quick go-to summary that you can refer back to is that economic damages are easily valued monetary amounts that you have paid out of pocket or are billed for. They include past and future medical costs, lost wages, loss of earning capacity, property damage. Now, let's talk about non-economic damages, which are also referred to as general damages. This category of damages include things like pain and suffering and mental and emotional distress, diminished capacity to labor, and bodily disfigurement. These damages are the most frequent source of disagreement in settlement discussions because there is no clear mathematical formula for determining them. Under Georgia law, the standard is enlightened conscience of a fair and impartial jury. Because nobody knows for sure what a jury will do in any given case, the amount of non-economic damages an injured person is entitled to receive can be a hotly contested issue. Remember from our workers' comp videos that areas of uncertainty can be a good or bad thing, as insurance companies typically don't like uncertainty, and a good attorney can use that to maximize the value for you by correctly communicating to the insurance company the full extent of their worst case scenario. A common myth is that insurance companies offer injured people 3 times their economic damages as compensation for their pain and suffering. This is simply not the case, or there are many factors that go into determining a case's value. Although no two cases are the same, insurance companies and personal injury attorneys will frequently use their experience handling injury cases as well as past verdicts and settlements that are similar to your own to help determine the value of these damages. And of course, there is a benefit to having an attorney or a law firm with both good verdicts and good settlements, because that attorney can then specifically point to the insurer that they themselves have hit the insurer with a big verdict for a case similar to yours, and that they might do it again if the insurer does not settle for a fair value. A quick go-to summary that you can refer back to is that non-economic damages are not as easily valued, and they include things like pain and suffering, mental anguish, emotional distress, loss of consortium, which is the spousal relationship, loss of enjoyment of life. That's pretty much it for the example. In some cases, an expert may be required to establish future medical costs or non-economic damages. Now let's talk about the third category, which are punitive damages. Those are awarded where there are aggravating circumstances that justify an award of damages to punish, penalize, or deter a defendant. They are only appropriate when there is clear and convincing evidence that the defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that the entire want of care would raise a presumption of conscious indifference to the consequences. In car accident cases, punitive damages are most common when the driver was drunk, under the influence of drugs, or texting at the time of the accident. Some insurance policies will exclude punitive damages. Although punitive damages can only be given by a verdict, a good attorney can use these in negotiations by illustrating to the insurer what a jury might award. So keep that in mind. In Georgia, punitives can be up to $250,000. So in an extreme example where you only have, let's say, $1,000 in medical bills, but you were hit by a drunk driver texting on his phone while driving with the lights off the wrong way in a one-way street, your attorney can still ask for full policy limits by asking for owed medical bills plus the rest in punitives. There's a lot more nuance to this, but this is an extreme example simply to illustrate the principle. Another major factor in determining how much your case is worth is the severity and longevity of your injuries. In general, the worse you're hurt, the more money that you will recover. That is because you will have higher medical costs, lost wages, pain and suffering, and other damages due to the more severe injuries that last longer. Commonly overlooked damages, which is an area of interest, and it really comes down to most people being familiar with medical costs and lost wages, but there are some known lesser damages to think about. Without legal help, you could be leaving some compensation on the table. For example, in addition to lost wages, you may no longer be able to complete your previous job functions. For instance, if you can't move like you used to, you may have what is called a loss of earning capacity, which means that you can no longer earn as much as you once could. This loss will be ongoing through the rest of your career. It can add up to hundreds or thousands of dollars or even millions of dollars. If your loved one died in an accident, you might not realize that you can get compensation to pay for all your past and future losses as well. You can get money to cover funeral and burial costs, and you can even get compensation for the expected inheritance that you will no longer get because of the death of your family member. Now, there are some value formulas when it comes to these personal injury cases. Some insurance companies use the formulas to determine the value of a case. Two popular examples that are often discussed are the multiplier formula and a per diem formula. A multiplier formula, in theory, uses all of your economic damages and multiplies them to value non-economic damages. For example, if you have $100,000 in medical bills, lost wages, and other economic damages, the insurance company may multiply that by 2.5 to value your economic damages for $250,000. The insurance company may then offer you $350,000 in total as a settlement. In our experience, formulas are not common and give many clients a false impression of what damages are attainable. However, if an insurance company uses a per diem formula, they may apply value to each day that the accident has impacted you and make you an offer for the total time they feel your life was affected by these injuries. For example, if the insurance company allows for $100 per day and your injuries persist for 100 days, they may offer you $100,000 as a settlement. Now, we have to talk about considering your degree of fault. Georgia is a modified comparative negligence state. That means that if you were partially at fault for an accident, you might still be able to recover compensation as long as you were less than 50% at fault. You can collect compensation from the other party. For example, if you were 49% at fault for the accident and had $100,000 in damages, your recovery would be reduced by $49,000. You could still recover $51,000 from the other party. All right, let's talk about some common complications. So, insurance companies will do everything they can to cause problems with a personal injury claim. They are in the business to make money. They don't want to pay out victims, no matter how strong your case is. Their business model is to take monthly premiums from drivers and then pay out less than the premiums. So keep that in mind in any type of dealings that you have with the insurance company. They want to profit as much as possible. So they will take any chance they have to pay as little as possible or not pay at all. It's simply a business transaction to them. Which leads me to disputing liability, which is the first thing they will usually try to dispute. Insurance companies will often dispute liability and claim that their insured is not at fault. Or in Georgia, they may try to place more of the blame on you. Everything you say to an insurance company will be used against you. You should be wary of talking to an insurance company, even on your own without speaking to your attorney first, even if you're talking to your own insurance company. Your attorney can help you think clearly and develop safe answers to these questions the insurance company will ask. Your attorney can also handle all communication so you don't have to stress over it. Now, even after proving that they are liable or them accepting liability, they will then try to dispute the actual damages. Insurance companies will deny or dispute any claims whenever possible. Remember that. They may refuse to pay your medical bills, fail to cover your property damage, and cut corners whenever possible. Insurance companies may even require you to be evaluated by their own doctors to determine if you actually need continued medical treatment. Of course, these doctors work for the insurance companies and will most likely give completely biased and unfair reports. So keep that in mind as well. I do have another video where I cover in depth how doctors work for insurance companies. And it's important that you work with a personal injury attorney who will fight back when the insurance company tries to dispute your economic and non-economic damages. If you have any questions, I do have my phone number in my profile here. You can also reach me on social media or just leave a comment, and then I will be able to reach back. And I hope you had a good grasp, or this video helps you get a good grasp on how to value your personal injury claim.